Welcome to Entrepreneurship Vertical. In the title, Intellectual Property Rights in the course Startup Formation and Scalability. In this lecture, we are planning to discuss about why IPR is required for new innovation. In the startup journey, we started with the innovation. We are ending with the scalability and enterprises. In the midway of our startup journey, particularly after TRL 5, we are going for intellectual property rights. IPR is very important for protecting our innovative design or innovative ideas. So after technology readiness level or 4 or 5, we need to protect our idea, otherwise someone take this idea for their progress, their promotion. So main objective of intellectual property rights, mainly for protecting our idea for future. First we will see the definition of intellectual property rights. It's a legal protection granted to protect the creation of the mind, such as invention or literature or work design, sometimes symbol. There are 7 main types of intellectual property rights, mainly copyrights, trademarks, patent, geographical identification, plant variety, industrial design and semiconductor design, circuit layout, especially for integrated circuits. So why we need this type of protection? Otherwise somebody will take that invention for their own progress. For easy understanding, the intellectual property is taking from the human brain. From the human brain, we have literature, artistic work, scientific invention, technical invention. We are taking into intellectual property rights in terms of patent, then trademarks, copyright, then trade secret. Mainly patents are focusing our innovation. Trademarks mainly for symbols, branded items. Copyright focus for literature. Trade secret, they have one special product. They only can able to give that product. That is a universal selling power. They have trade secret. For that they are protecting based on IPR. So connecting from human mind to patent, trademark, copyright, trade secret by the nature of work. Nature of work may be literature or architectic work, then scientific invention, some technological innovation. These are the things regularly making a copyrights or trade secret, patent by means of intellectual property office. Now, what is the scope of IPR? IPR, intellectual property rights, is mainly focused for creation of the mind that protected by the law. It includes patent for innovation, copyright for literature, trademarks for brand recognition, and industrial design for mainly for product, industrial product under the industrial design. Additionally, it covers trade secret, mainly geographical identification, then particular software development, some biotechnological innovation and artificial innovation. These and all under the trade secret. In the biotechnology, they have a new branded medicine. The branded medicine is having some secret that is maintained with suitable protection by means of trade secret. Now we have 2 major classifications. primary group and a secondary group. The intellectual property rights, we have a two major group. One is a primary. Under the primary, we have a patent, copyright, trademark and trade secret. Patent for innovation, already we explained many times. Patent for innovation, copyright for literature, trademark for brand, especially in the brand we have a unique selling proposition that is under the trade secret. In the secondary group we have contract, industrial design, layout design, particularly for integrated circuit chips, then geographical identification. These are in the secondary group. Based on primary group and the secondary group, we have different type of form application, everything. So we first find whether it is a primary group or secondary group, we need to classify. Now what is the policy of IPR? National Intellectual Property Rights Policy adopted in the year 2016, which aims to foster a innovation improvement and creativity in India by promoting the generation, protection and commercialization of intellectual property. It emphasizes all form of IPs including patent, trademarks, copyright and industrial design and seek to strengthen the institutional framework for IP management. Intellectual properties number is increased, particularly in the institution. Most of the technology based institution, they are having IP, number of patents. Each department per year they are applying more than 10, few of them from 5 to 7 it is coming for publication, 3 to 4 coming for grant also. The main policy aim enhance the public awareness about the economic, social and cultural background of IPR. IPR first creating awareness, then they are giving some regulation. These are the things do, these are the things will not apply for patent. Then we are going for publication through proper channelizing the copyrights, everything verified by the patent officer, they are calling controller of patent, then publishing, then going for grant. So we have few advantages and many disadvantages in the IPR. IPR connecting innovative idea to angel investor through technology transfer unit. So innovator always developing new things. They are having a new idea, they are developing based on the industry or social problem. Now we are taking into final stage for scalability. During that time we need to transfer. Before transfer we need protection. For that protection we are going mainly by IPR, intellectual property rights. Based on the rights only we are promoting into next level. So main objective, we need to protect our innovative kind of things, design based on our requirement. For that requirement we are writing claims. What are the things we are going to claim? So writing claim is important part. So invention one side, another one is side scalability. In between we have a technology transfer unit. Based on the technology transfer unit, we will take the innovative idea to scalable. Before that, we want to go for protection. We have few advantages. Main advantages: primary, innovation, promoting economic growth and fostering more competitive marketplace. We are giving protection, the same time that protected idea by means of patent, trademarks, copyright or trade secret, it is giving, improving the economic growth. These advantages include legal protection for creation, then attracting investment, boosting business reputation, enabling technology transfer. Because of IPR, what are the things available? If you know the title, we can go and discuss with the people by the innovator through the IPR. This is a problem. The solution is given. How to solve that problem? The angel investors are ready to get the IPR through IPR for the defined patent. Based on that, they are mentioning many problem through technology transfer cell. We have the advantage again, legal protection for innovation, potential income through licensing, then increased business value and competitive advantages in the market. It determines mainly economic growth and ensure consumer protection while promoting innovation into globally. So major advantage include economic growth and ensure the customer protection and promoting innovation globally. So what are the things here mainly for disadvantage? When you are taking the IPR, we need to spend money and time. So in the time spending, we are interested in the innovation, but the same time we need protection. That's why Government of India, most of the incubators are connected with the IPR cell. IPR cell having a member, they will give how to write claims and all. The claim writing is important art. We are making that into suitable claim. Based on the claim only, our ideas are protected. So first, in the major disadvantage in IPR protection, number one, we need to spend quality time and money. Then sometime while going for IPR, before reaching that IPR, getting progress in terms of publication or some type of grant, the major issue during the discussion, some important valuable point also disseminating through some other channel. So before going for protection of that idea, we need to protect our formula. So what are the claims we have? We need to discuss with our patent officer. So within a short period, we need to apply and get a patent number. After applying, we have some claims. If somebody is taking after the particular date of claim, we will go for suitable rights for getting our benefit. So number one, we need to protect. The same time during the protection, we need to write proper claim. The claim, based on the claim only, our protection is ensuring. Now, very complex problem and challenging problems is very difficult to raise in the patent claim. That is a major difficulties in the protection. So during that time, we need some lawyer and patent attorney for writing all those things. What are the claims? How to get proper protection? So innovator, they are going for IPR, patent right, patent protection. That time, maximum time and money and manpower utilization is a complex in the IPR protection. The same time, if you raise some proper claim, that may be very good economical asset for the innovators. So what are the things we need to consider? One end, innovation. Another end, we have a scalability. During this journey, IPR giving suitable protection for our idea. Based on our protection, we will go for next economical growth. Now we will have some discussion particularly in the trademark. Trademark mainly for they are having a symbol or sometimes they are having a brand name. With their brand name, they are able to sell. That market fit is proper for that brand. If I am doing the same brand with the same name, if I am giving a product, means definitely they will go for claim. That is a court will getting suitable issue. So IPR is very important for new innovation, getting patent. For literature, they are writing some music, these and all mainly getting protection for through the proper copyrights. Third one is a trademarks, particularly for business, they are getting suitable symbol, trade, everything. Another one, trade secret. That is our commercial selling point, suitable point we want to understand. With this, we understand what are the importance of IPR. Thank you.